Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. Intake shouldn't be the hardest part of your day or your client's day, but for most firms it is. Intelligent Form Intakes from e-Immigration is the legal tech breakthrough award-winning way to collect client information with less stress and more accuracy. Clients complete their forms in their language, and e-Immigration instantly translates everything back into English and drops it right into your forms and case files. It's faster, it's clear, and it removes hours of manual cleanup every week. See why firms everywhere are switching to Intelligent Form Intakes at get.eimmigration.com, or click on that special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
Welcome back, everybody. It's Liz Montano here again, filling in for Kevin. I hope you're all enjoying the holidays and carving out at least a little time to relax and reflect on the past year. Or, honestly, just fully disassociate from it. Both are valid. If Kevin were here, he'd definitely be thanking you all for tuning in week after week to talk through the cases with him during what's been, let's be real, a pretty stressful and challenging year. Since he's not here and I am, I'll say it instead. Thank you all genuinely for listening, sticking with the pod, and being part of this community. All right, we've got 4 cases this week, 1 from the BIA and 3 from the circuits. And a fair warning, none of them are particularly friendly to non-citizens, but they are interesting, and there's a lot to unpack. So, without further ado, let's jump in, so you can get back to disassociating on the couch as efficiently as possible. First up is matter of Ghanbari from the BIA. This is a precedential bond decision from the BIA, which was actually decided in October but was just designated for publication by the Attorney General this week. DHS alleged that Mr. Ghanbari is subject to mandatory detention under INA Section 236C1D, which applies to non-citizens described in INA Section 237A4B, including those who have provided material support to a terrorist organization. The alleged organization here is MEK. While MEK was not a designated terrorist organization at all relevant times, DHS asserted that it nonetheless qualified as a terrorist organization under the statute. To oppose Mr. Ghanbari's bond request, DHS relied primarily on statements he made in his refugee application, including that he was a sympathizer of MEK from 1980 to 1987, that he engaged in propaganda activities, that authorities found MEK leaflets, papers, and books in his home, and that he was detained by Iranian authorities for involvement in, quote, Mojahideen activities, end quote. DHS also submitted background evidence, including Congressional Research Service materials describing MEK's violent activities in the early 1980s. After a bond hearing, the IJ concluded that DHS was substantially unlikely to prevail on the charge that Mr. Ghanbari provided material support to a terrorist organization. As a result, the IJ found that mandatory detention did not apply. The IJ reasoned that Mr. Ghanbari was approximately 15 to 16 years old during the relevant period, that his activities were limited to non-violent propaganda, and that he did not know and should not reasonably have known of MEK's violent activities at the time. Because the IJ found Section 236C inapplicable, the IJ asserted jurisdiction under 236A and found that Mr. Ghanbari was not a danger or a flight risk and granted him bond. DHS appealed to the BIA, arguing that the IJ lacked jurisdiction to conduct any bond hearing, that the respondent failed to meet his burden to show that Section 236C did not apply, and that the IJ misapplied the, quote, substantially unlikely to prevail, end quote, standard. DHS emphasized that Sixth Circuit precedent, where this case arose, holds that MEK was a terrorist organization during the relevant time period, and even nonviolent conduct, such as distributing flyers, can constitute material support. The BIA agreed, sustained DHS's appeal, and vacated the bond order. As we know, if INA Section 236C applies, the IJ has no authority to conduct a bond hearing, and the non-citizen is subject to mandatory detention. And under 8 CFR Section 1003.19 H2II, the respondent bears the burden to show that DHS is substantially unlikely to prevail on the charge triggering mandatory detention. First, the BIA reaffirmed that DHS does not need to charge the non-citizen under the terrorism ground in the NTA. Instead, the inquiry is whether the respondent is, quote, described in, end quote, INA Section 237A4B. Second, the BIA found the IJ's analysis of Mr. Ghanbari's alleged material support to MEK to be both legally and factually flawed. Factually, the BIA emphasized evidence supporting DHS's position, including Mr. Ghanbari's admissions that he was an MEK sympathizer and engaged in propaganda activities, his statements that Iranian officials found MEK materials in his home and detained him for MEK-related activities, and background evidence showing that MEK engaged in violent acts as early as 1981, including a bombing that killed Iran's Chief Justice and dozens of officials. Legally, the BIA relied heavily on the Sixth Circuit's 2018 decision in Hosseini v. Nielsen, where the court held that MEK operated as a terrorist organization at least until September 1981, and that distributing flyers constitutes material support, even when the activity itself is nonviolent, because it, quote, gives legitimacy to the organization while it engaged in terrorism, end quote. The BIA also rejected the IJ's reliance on Mr. Ghanbari's young age at the time of the conduct. The BIA explained that the IJ ignored evidence outweighing age and that the respondent failed to rebut that evidence. In particular, the BIA contrasted this case with Dineshvar v. Ashcroft, noting that, unlike the non-citizen there, Mr. Ghanbari did not testify at the bond hearing, did not present evidence that he was unaware of MEK's violent activities, and did not show affirmative dissociation after learning of that violence. As a result, the BIA concluded that it could not, quote, conclude that DHS is substantially unlikely to establish, end quote, that the respondent's actions would support removability under INA Section 237A4B. The BIA therefore held that the IJ lacked jurisdiction to grant bond, vacated the bond order, and ordered Mr. Ghanbari detained without bond because he is subject to mandatory detention under Section 236C1D. This is a detention-expanding precedent with several key takeaways. First, the BIA reinforces an extremely strict standard for Joseph hearings, emphasizing that overcoming mandatory detention requires, quote, very substantial grounds, end quote, and that silence or lack of testimony by the respondent may be fatal. Second, the decision makes clear that youth alone is not enough. Even juvenile conduct can constitute material support under Section 237A4B and trigger mandatory detention years later, especially absent evidence of lack of knowledge or affirmative disassociation. And third, the BIA firmly adopts the position that propaganda equals material support, that even nonviolent activities like flyers, advocacy, or expressions of sympathy can suffice. And that was Matter of Ghanbari.
Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a U.S.C. denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out.
Next up, Ramos-Hernandez v. Bondi, published by the First Circuit on December 22, 2025. This is an asylum case involving Guatemalan extortion claims, small business PSG theories, and family-based nexus arguments. The First Circuit doesn't really break new ground here, but it does apply existing circuit doctrine and, in doing so, reinforces just how narrow the path remains for these kinds of cases. The respondents are Mr. Ramos-Hernandez, his wife Ms. Lopez, and their minor daughter. All are citizens of Guatemala. They entered the U.S. in September of 2021 without inspection and were placed in proceedings approximately 1 month later. They applied for asylum, withholding of removal, and cat protection. At the merits hearing, the couple testified that Ms. Lopez completed high school in Guatemala and obtained a teaching certification, but had difficulty finding employment, in part because she lost a finger in a childhood accident. She eventually worked at her uncle's hardware store. In 2018, the uncle retired and sold the store to Ms. Lopez and Mr. Ramos-Hernandez. Around 2019, Ms. Lopez began receiving anonymous extortion demands, first by text message from an unknown number and later by a written note, demanding payment in exchange for continuing to operate the store. Around that same period, Mr. Ramos-Hernandez was physically attacked while riding his motorcycle. Unknown assailants struck him from behind with a tree branch, knocked him unconscious, and beat him. The record contained inconsistencies regarding the timing of the attack, and there was no direct evidence tying it to the extortion demands. Following the threats and the attack, the couple reduced the store's hours and eventually closed the business entirely. They then remained in Guatemala for approximately 2 years without further incident before leaving for the United States. They testified that they were concerned about increased criminality in Guatemala and the safety of their children. After the merits hearing, the IJ found the non-citizens credible, but denied all forms of relief. With respect to asylum, the IJ concluded that the couple failed to establish either past persecution or a well-founded fear of future persecution on account of a protected ground. As to past persecution, the IJ characterized the harm as, quote, sporadic mistreatment on a couple of isolated events, end quote, and concluded that it did not rise to the level of persecution under First Circuit law. As to future persecution, the IJ emphasized that, quote, there was no reasonable possibility the petitioners would be singled out again, end quote, because the couple had closed the business that allegedly triggered the extortion and had not received any threats unrelated to it. The IJ also found that the couple failed to show they could not reasonably and safely relocate internally, noting that they did not know who the extorters were or how they could locate them elsewhere, and that they lived in Guatemala for 2 years without incident after closing the business. The IJ also rejected each asserted nexus. As to particular social group, the IJ rejected the proposed group of, quote, Guatemalan small business owners, end quote, because it lacked immutability and particularity. The IJ reasoned that business ownership can change and is not fundamental to identity, and that the group was impermissibly broad, seemingly encompassing all small business owners in Guatemala, regardless of age or background. The IJ also rejected the proposed group of the, quote, Lopez Ramos-Hernandez nuclear family, end quote, explaining that harm to multiple family members does not, by itself, establish that kinship was a central reason for the harm. And it did not do so here, because, quote, the evidence does not show that the petitioner's familial relationship to the Lopez Ramos-Hernandez nuclear family was at the root of the harm they experienced, end quote. The IJ further rejected the claim that the couple was targeted based on an anti-gang political opinion, finding no evidence that they publicly expressed such an opinion, that the perpetrators were gang members, or that any harm occurred because of a political belief. So because the couple failed to meet the asylum standard, the IJ denied withholding of removal as well. And as to cat protection, the IJ concluded that the harm did not rise to torture, that internal relocation was available, and that there was no evidence of government acquiescence. The couple appealed to the BIA, which affirmed without opinion under 8 CFR section 1003.1E4. As a result, the IJ's decision became the final agency determination for purposes of the First Circuit's judicial review. The First Circuit denied the petition for review, applying its usual substantial evidence framework and reiterating that it may reverse only if the record compels a contrary conclusion, not merely because an alternative view of the evidence is possible. And as the court put it, quote, substantial evidence supports the IJ's determinations against the petitioners. The petitioners cannot establish that their past persecution or fear of future persecution is on account of a protected ground, so their asylum claims must fail, end quote. The court first addressed the proposed PSGs. As to the small business owner PSG, The court had little difficulty affirming the IJ's decision. Citing cases like its 2024 decision in Cabrera v. Garland and its 2023 decision in Sanchez v. Garland, the court explained that it has repeatedly held that PSGs defined by business ownership or perceived wealth are not cognizable because they are overly broad and do not implicate an immutable characteristic. Although Ms. Lopez argued that business ownership was fundamental to her identity, the court pointed out that the record showed she trained as a teacher, sought other employment, and ultimately closed the business. That evidence did not compel a finding that business ownership was immutable or central to her identity. As to the family-based PSG, the court reaffirmed a familiar rule. Quote, the mere fact that members of the same family were harmed does not establish that the family connection was a central motivation for the suffered harm. End quote. Here, the record supported the conclusion that the couple was targeted because they ran a successful business, not because of their familial relationship. The court also rejected the political opinion theory, explaining that simply holding a political view is not enough to show persecution on account of that belief. Rather, the applicant must show that the persecutors knew of the political belief and targeted the applicant because of it. Refusing to pay extortion demands, even if framed as opposition to gangs, was insufficient, and the record lacked evidence that the persecutors were motivated by any political opinion. As to past persecution, the court agreed that the threats and single beating, particularly given the unknown motive, inconsistent timing, and unclear nexus, did not compel a finding of persecution. The court noted that it has rejected past persecution claims involving even more severe harm and reiterated that, quote, persecution goes beyond unpleasantness, harassment, and even basic suffering, end quote. As to future persecution, the court emphasized that the petitioners lived safely in Guatemala for approximately 2 years after the threats and after closing the business. Because the couple had not, quote, presented credible, direct, and specific evidence supporting a fear of individualized future persecution, end quote, and given the availability of internal relocation and the absence of a protected ground nexus, they failed to establish a well-founded fear of future persecution. Because the asylum claim failed, the court affirmed the denial of withholding of removal, and as to CAT, the court held that there was no compelling evidence that the petitioners would face torture, let alone torture with government acquiescence, upon return to Guatemala. And so, the First Circuit denied the petition for review. And that was Ramos-Hernandez v. Bondi. Next up, Campuzano v. Bondi, published by the Fifth Circuit on December 22, 2025. This is a case that has two main issues. First, the authentication of criminal records, and second, the always fun, always interesting categorical approach. Mr. Campuzano is from Mexico and was a lawful permanent resident. While a lawful permanent resident, he pled guilty in Texas state court to, quote, indecency with a child sexual contact, end quote, under Texas Penal Code Section 2111A1, a second-degree felony under Texas law. DHS initiated removal proceedings against Mr. Campuzano in December 2023, charging him as removable under INA Section 237A2EI for having been convicted of a, quote, crime of child abuse, end quote. To establish removability, DHS submitted several documents: a Form I-213, a police report, the indictment, and an order of deferred adjudication. DHS also submitted Mr. Campuzano's bond application, where he himself admitted to being found guilty of indecency with a child. Mr. Campuzano admitted his alienage and LPR status, but refused to admit the conviction and denied removability. He then moved to terminate proceedings, arguing two things. First, that the conviction was not properly authenticated, and second, that the Texas offense is not categorically a crime of child abuse. He also alternatively applied for cancellation of removal. As to the first argument, Mr. Campuzano argued DHS failed to authenticate the conviction records under INA Section 240C3C and the Immigration Court Practice Manual. Specifically, he argued that the records were, quote, not accompanied by a certification from a DHS official that the alleged conviction document was received from a state court repository, nor a certification from a state official as an official record or by a court official from the court where the conviction was entered, end quote. He argued that these authentication methods are mandatory and that there must be compliance whenever the government introduces electronic records of a conviction, so his conviction records were inadmissible. But the IJ overruled the evidentiary objections and admitted the records. As to the second argument, the IJ applied the categorical and modified categorical approaches and concluded that Mr. Campuzano was indeed convicted under Texas Penal Code Section 2111A1 and that the offense categorically qualifies as a crime of child abuse under INA Section 237A2EI. As to Mr. Campuzano's application for cancellation of removal, the IJ denied the application as a matter of discretion. As a result, the IJ ordered Mr. Campuzano removed to Mexico. On appeal to the BIA, Mr. Campuzano raised the same three arguments. As to the authentication of the conviction records, the BIA acknowledged that DHS did not comply with the certification methods listed in INA Section 240C3C. But the BIA nevertheless held that those authentication methods are, quote, not mandatory or exclusive means of authenticating conviction records, end quote. In other words, while those methods may be one way to authenticate records, they are not the only way. As to the crime of child abuse issue, the BIA held that Texas Penal Code Section 2111A1 is categorically a crime of child abuse. And as to cancellation of removal, the BIA affirmed the IJ's discretionary denial. Mr. Campuzano then petitioned for review to the Fifth Circuit, which ultimately denied the petition for review in full. Two major holdings make this case notable. First, the authentication of electronically submitted conviction records issue was a question of first impression for the Fifth Circuit. Although the court acknowledged that it was, quote, undisputed that the conviction records were not authenticated, end quote, pursuant to INA 240C3C, the court held, using the Ninth Circuit's 2006 decision in Cenotes Cruz v. Gonzalez and the Eighth Circuit's 2015 decision in Frazier v. Lynch as support, that Section 240C3C creates a safe harbor, not a mandatory rule, because the statute's use of the, quote, sufficient if rather than the necessary only if, end quote, means it sets a sufficient but not necessary condition for admissibility. Therefore, the Fifth Circuit concluded that the BIA did not err in admitting the conviction records, despite the failure to comply with the authentication procedures in INA Section 240C3C. Second, the court addressed whether Texas Penal Code Section 2111A1 is categorically a crime of child abuse. Of course, because Texas Penal Code Section 2111 contained two alternative offenses, the court applied the modified categorical approach and found that the record clearly showed a conviction under Section 2111A1, which is a second-degree felony criminalizing sexual contact with a child. Having determined the exact statute of conviction, the court next had to determine whether the conviction was categorically a crime of child abuse under INA Section 237A2EI. Using the BIA's decision in Velazquez-Herrera, which the Fifth Circuit recently upheld in its 2025 decision of Sandoval-Argueta v. Bondi, post-Loperbright, the court found that the BIA defines the term crime of child abuse, quote, broadly to mean any offense involving an intentional, knowing, reckless, or criminally negligent act or omission that constitutes maltreatment of a child or that impairs a child's physical or mental well-being, including sexual abuse or exploitation, end quote. Under this definition, three elements are required for an offense to qualify as a crime of child abuse. 1, it must be committed against a child under 18. 2, it must be an act done with at least criminal negligence. And 3, the act must constitute maltreatment or impairment of physical or mental well-being of a child. While Mr. Campuzano relied on matter of Silva-Trevino and argued that the statute criminalizes mere offensive touching and lacks a sufficient harm element, the court outright rejected his argument. As the court explained, sexual contact under Texas Penal Code Section 2111A1 is not benign touching, but instead criminalizes touching of, quote, specific enumerated body parts, end quote, done with, quote, the intent to arouse or gratify the sexual desire of any person, end quote, all of which would qualify as sexual contact, which, quote, necessarily involves acts that impair a child's physical or mental well-being, end quote. As a result, Texas Penal Code Section 2111A1 satisfies the harm element and, quote, categorically fits within the BIA's definition of a crime of child abuse, end quote. As a result, the Fifth Circuit denied the petition for review. This case cements two important points in the Fifth Circuit. 1, INA Section 240C3C is a safe harbor, not a gatekeeper. And 2, a conviction under Texas Penal Code 2111A1 is squarely a crime of child abuse. And that was Campuzano v. Bondi.
Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in.
Founded and led by veteran immigration attorney Irina Rostova,
EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists.
doing business as Invest America. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
And lastly, Ruiz v. Bondi, published by the Ninth Circuit on December 22, 2025. This case involves asylum, withholding of removal, cat protection, and administrative closure. But the most interesting, and by far the longest, part of the opinion is actually jurisdictional. The panel takes a deep dive into whether federal courts can review extraordinary circumstances determinations for untimely asylum applications under INA Section 208A2D after the Supreme Court's decision in Wilkinson v. Garland. So, while Mr. Ruiz, spoiler alert, ultimately loses across the board, this decision matters because it reshapes how the Ninth Circuit now understands judicial review of what it calls, quote, discretionary mixed questions, end quote. Mr. Ruiz is a native and citizen of Nicaragua. His claim is rooted in events that occurred during the Sandinista Revolution and Civil War in the late 1970s and early 1980s. Mr. Ruiz grew up in a family aligned with the Nationalist Liberal Party, which opposed the Sandinistas. When Mr. Ruiz was 4 years old, a Sandinista militant killed his father in Managua for criticizing Sandinista policies. Mr. Ruiz's mother demanded an investigation, and Sandinista authorities responded by telling her to forget it, and they threatened to kill her. Sandinista groups came to the home, yelled at her, and spray-painted threats on the walls. As a child, Mr. Ruiz and his siblings were forced into Sandinista youth organizations. He testified that when he was 5 or 6, he was forced to dig trenches in preparation for air raids, and that on the way to school, he would walk past burned bodies left on the roadside as warnings to opponents. Other family members were killed or dispossessed, and an uncle fled the country. In 1984, when Mr. Ruiz was 9, the family moved to the United States. But in 1994, when Mr. Ruiz was 19, his mother's asylum application was denied, and the family returned to Nicaragua. Mr. Ruiz then lived in Nicaragua for several years without harm. His mother remained there until 2001, and his sister stayed in Nicaragua as well, also without incident. Mr. Ruiz later lived in Guatemala for about a decade, married and had a child. He returned to Nicaragua briefly in 2001 and 2005, again without harm. In 2006, Mr. Ruiz moved back to the United States and settled in Oregon. Mr. Ruiz struggled with alcohol abuse and accumulated 3 DUI convictions. Immigration proceedings restarted after the last conviction, and Mr. Ruiz applied for asylum, withholding of removal, and cat protection, more than 13 years after his arrival in 2006. And the immigration judge denied everything. As to asylum, the IJ found the application to be time-barred and concluded that Mr. Ruiz failed to show extraordinary circumstances excusing the delay. Mr. Ruiz argued that childhood trauma had long-term mental health effects, but the IJ found that he didn't explain how the trauma prevented him from filing within a year, or for the next decade. As to withholding of removal, the IJ concluded that Mr. Ruiz failed to establish past persecution, failed to show a nexus to a protected ground, and, in any event, found that conditions in Nicaragua had fundamentally changed since the early 1980s. The IJ emphasized that Mr. Ruiz returned to Nicaragua multiple times without incident and had never been politically active and could relocate internally. For similar reasons, the IJ denied cat, finding the risk of torture speculative. While the appeal was pending, Mr. Ruiz married a U.S. citizen, and USCIS approved the spouse's I-130 petition. So Mr. Ruiz moved for administrative closure to try to pursue a provisional unlawful presence waiver. But the BIA denied administrative closure, citing DHS's opposition based on Mr. Ruiz's criminal conduct and immigration history, and explaining that administrative closure wasn't necessary because the regulations provide an alternative pathway to pursue a waiver after the removal order becomes final and Mr. Ruiz obtains consent to reapply for admission. The BIA then dismissed the appeal and affirmed the IJ across the board. Mr. Ruiz petitioned for review in the Ninth Circuit. And before it even gets to the merits, the Ninth Circuit spends a huge amount of time answering the threshold question. Can the court review extraordinary circumstances determinations under INA 208A2D? Historically, the Ninth Circuit's 2007 case Ramadan v. Gonzalez treated extraordinary circumstances determinations under INA Section 208A2D as reviewable mixed questions and, crucially, as not discretionary. But the panel says that part of Ramadan's reasoning is clearly irreconcilable with the Supreme Court's 2024 decision in Wilkinson v. Garland. Why? Because Wilkinson emphasized that when Congress uses language like, quote, to the satisfaction of the Attorney General, end quote, it signals that even the threshold determination involves discretion. And INA Section 208A2D uses exactly that language. So, the Ninth Circuit says, in essence, Ramadan v. Gonzalez was wrong to treat the extraordinary circumstances determination as non-discretionary. But, and this is the important pivot, the court says that that doesn't end the inquiry, because not every discretionary determination is automatically unreviewable. And at this point, listener, the opinion takes a long, long walk through statutory structure, legislative history, and competing Ninth Circuit precedent. It's a lot. So here's the boiled-down version. The panel concludes that extraordinary circumstances determinations do not fall within the exception at 8 U.S.C. 1252A2Bii for discretionary determinations, quote, under Section 1158A, end quote, because apparently that statutory cross-reference is basically a drafting mess left over from era's rewrite of the asylum statute. But the court says review still exists under a different route, 8 U.S.C. 1252A2D, which preserves judicial review of constitutional claims and questions of law. And here is the key move. After Wilkinson, the Ninth Circuit treats mixed questions of law and fact as questions of law for purposes of 1252A2D, even when the mixed question is discretionary. The court leans heavily on post-Wilkinson Ninth Circuit precedent, particularly its 2024 decision in Martinez v. Clark, the second one, to explain why that works. The idea is that even when a legal standard is, quote, malleable and involves agency discretion, end quote, it can, quote, still be a legal standard, end quote. And courts can review whether the agency properly applied that legal standard to the facts. So the court holds, Extraordinary circumstances determinations are discretionary, yes, but they are also mixed questions, reviewable under 8 U.S.C. 1252 A2D. However, the court adds an important qualifier. When the mixed question is primarily factual, review is deferential under the substantial evidence standard. So, to translate, the court can review extraordinary circumstances determinations, but it's not a do-over. It's more like, did the agency have enough evidence or substantial evidence to reasonably reach this result? And just for transparency, this jurisdiction section takes up roughly half the opinion. I did my best to capture the meat and potatoes, but there are a lot of important drippings in there, so if you're litigating this issue, you'll want to reread those pages closely. All right, deep breath. Now, to the actual merits. Applying that deferential substantial evidence standard, the Ninth Circuit upholds the BIA's conclusion that Mr. Ruiz did not show extraordinary circumstances to excuse the 1-year filing deadline. The court acknowledges that trauma can qualify as extraordinary circumstances. Regulations even contemplate mental illness or disability, including effects of past persecution. But the court emphasizes that the applicant must explain the causal link. How did the trauma actually prevent timely filing? And Mr. Ruiz did not do that. In particular, he failed to explain how childhood experiences decades earlier caused a 13-year delay after his 2006 entry. The panel says that without an explanation, the agency would be left to speculate about whether the delay was reasonable. So the denial stands. Turning to withholding, the court holds that even assuming past persecution, substantial evidence supports DHS's rebuttal based on changed country conditions and the record of Mr. Ruiz's own safe returns. Mr. Ruiz attempted to argue that he would be persecuted based on his political opinion, but the court quickly rejected that as well. According to the Ninth Circuit, the record does not compel a contrary conclusion, and the court affirmed denial of the withholding of removal, and the CAT claim failed for essentially the same reasons. Finally, the Ninth Circuit affirmed the BIA's administrative closure denial. And after all that, the Ninth Circuit denied Mr. Ruiz's petition for review. The lasting impact of this case is not really the outcome on the merits. It's the jurisdictional holding. But, in a footnote, the Ninth Circuit explains that before the IJ, Mr. Ruiz actually conceded that he was time-barred and sought only withholding and CAT protection. But the IJ nevertheless analyzed asylum and the extraordinary circumstances exception under INA 208 A2D. So, this basically means that there may exist an alternate timeline where the IJ never even reached the asylum exception issue, and this opinion is like 15 pages shorter. But, honestly, that alternate timeline sounds far less interesting. And that was Ruiz v. Bondi.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.